Good afternoon to all of you. Welcome to the Paro University webinar series. Today's topic is very interesting and very productive topic, a very informative topic. The topic is the need to understand the intellectual property rights, concept, and types. So here with us, we have Ms. Neha Khanduri as a speaker. She is BTech LLB and working as an associate in Sardul Amarchand Mangaldas and Company, New Delhi. Mr. Ms. Khanduri has been practicing IP litigations since 5 years. She has also prior experience in IP transactions. So without taking much time, I would like to invite Ms. Neha Khanduri for the topic.
Good afternoon to everyone. Firstly, I'd like to thank Professor Sharma for giving me this opportunity to address all of you on this interesting topic. Secondly, I hope that all of you and your families are keeping safe and are doing well in the time of pandemic. So firstly, I will like to just define the structure for today's webinar. So I will be dealing with all the forms of intellectual property in detail. Firstly, I will just go through the statute, particular law related to each intellectual property, then the underlying principles and the famous case laws, or to make it rather interesting, some practical examples that can make that can be better to understand the underlying principles of that particular intellectual property. And at the end, I'll be taking any queries or any questions that any of you may have. So before I start the session, I like to just share one experience of mine. So I have had an opportunity, without sounding pompous, I had an opportunity to work with few scholars from IISc Bangalore or IIT Delhi and IIT Mumbai. And when they approach any IP attorney for any intellectual property related query or any query related to protection for any patent or any discovery or any invention that they have come up, they usually have a tendency of using the terms interchangeably. Like they will say that, okay, I want a design patent, or when we just tell them that a patent may take 3 to 5 years, then they usually raise questions like, no, but I secured my design patent in a month. So usually, so most of the time, because of this ignorance, few of the practicing patent agents, they give false timelines to the scholars and then they are kept in dark. So by way of this session, I like to enlighten you all so that next time you have an invention that you feel can be patented, you can also be aware of few basics when you speak with any intellectual property attorney or a patent attorney for seeking statutory protection. So firstly, I'd like to start with patent. Patent, one of the most complex form of intellectual property. I've used the term complex here because when we say patent, technology gets involved, and from civil engineering to space engineering, all there are variety of patents that can be filed in any of the technology domain. You name one and you'll have thousands and thousands of patents in that particular technology domain. In the later section of this webinar, I will be throwing light on some agriculture technology related inventions and what IP will be relevant for students of agriculture technology. So when I start with patents, the basic concept behind a patent law is that one always gets a patent protection for an idea. So for a patent protection, first one needs to have an idea. then for being eligible for the patent protection, the idea needs to fall in the category of eligible subject matter. So any discovery or any invention that is contrary to moral laws, like suppose I come up with an invention for a theft, like for robbing a bank, or any device that can help me, or any software that can help me to hack the accounts and transfer money. So so this kind of invention will be an ineligible subject matter. Then I cannot file patent for a plant. I cannot come up with a patent for a tomato plant which bears tomatoes with red and orange lining. So these kind of inventions are pretty common in the field of agriculture, tissue culture, or genetics. People usually come up with red rose, black rose, white rose, purple rose. We all are aware of that. But such inventions are not patentable. Similarly, a software is not patentable. Whenever you incorporate a software with a hardware component, then it becomes an eligible subject matter. So the list of ineligible subject matter is exhaustive, and it is included under the Patent Act 1970. But since it is a preliminary session and I do not want it to be full of legalese and heavy on law, so this is why I'm not delving into details. Now, the basic concepts behind the patent are novelty and obviousness. Whenever you come up with an idea or an invention, it has to be novel. When I say novel, it means that it should not have been published in any document in the world. It should have not been published anywhere. Suppose today I come up with an invention, like I come up with an invention for, say, any novel engine which has less combustion time or which is more efficient or something like that. But a person in Pakistan, in any university in Pakistan or Bangladesh, had submitted a PhD where this invention was disclosed, then that publication will act as a prior art for my idea, and my invention will be rejected by the patent office. So whatever idea you come up with has to be novel. And when I say novel, we all stand on shoulder of giants, as was said by Newton or Galileo. I can't remember, but this is a famous saying in patent law. So even if you are taking an inspiration, there has to be a new component that you have added and that is contributing to your invention. So when we talk about novelty, we have to look for any published document which does not disclose your idea. Secondly, inventive step. Now, when we talk about inventive step, now going back to the previous example, suppose I have come up with an engine which has less combustion time or any other features. Since I'm not from mechanical engineering domain, I may not be giving a really relevant example. But suppose I have come up with an engine, then there should be a feature which should be contributing or which should be different from the engine that is already existing in the domain before I have come up with an engine. And this feature should contribute to my invention. That what am I doing that was not done before? Is there any economic significance of this feature to my invention? So this feature will be the inventive step of my invention. To give you a relevant example, this invention was dealt by me a few years ago. I will not give details of the invention, but it was from a research problem in IIT Delhi. So he had come up a vector for expression of a gene, and when that vector was inserted in an organism, then that particular gene was inserted, and that particular gene had some contribution to curbing cancer in human bodies. So so vectors are already known in the art. Some of you who may have any knowledge related to biotech will be knowing that what is a vector. So vector is already known in the art. Genes who not contribute, I mean, a cancer-causing gene, oncogenes are already known in the art. So what is that he has done so that his invention is has an inventive step? So the combination of he had not just used a vector, but he had used a combination of vectors which one could have not thought of, one could have not conceived, even while reading the previous art or the previous works of similar nature. So he had put two vectors, and then when he was expressing that gene in that organism, the expression was better. The and there were some other factors also. The markers were expressed in a better way. So this is a simple example to demonstrate what is an inventive step. While novelty is something that will be a new feature that was not disclosed anywhere, inventive step is a feature that gives your invention an extra edge. It can be any feature which also gives an economic significance to your invention. Now, while we are on the concept of inventive step and obviousness, I will give you a really interesting example of prior art. So, in 1964, in Kuwait, there was a ship which was carrying some 1,000 sheep. While the ship was already on the harbor, they were able to offload some 500 ships, and the other 500 sheeps. 500 sheeps were offloaded. The other 500 sheeps sank in the sea. So once the sheeps sank, the sheeps of course died, and then there was a threat of infection that would have spread in the sea, causing health hazards to the residents or the citizens of that particular country. And I think Kuwait, yeah, Kuwait, that was Kuwait. So people were trying to find ways how to get those 500 sheeps out of the sea. So one very obvious idea was to get a crane and to lift the sunk part of the ship from the sea. But this was pretty time consuming, and the health hazard was really affecting the lives of people. The lives of too many people were at risk. So there was one Danish inventor. What he did was he filled the sunken part of the ship with some plastic balls, and applying the concept of buoyant force, which we had studied in physics while we were in 7th or 8th class. He just lifted the sunken part of the ship. So once he did that, he filed a patent application for this idea that whenever there is a part of a ship, and in those times it was pretty common that a part of the ship used to get sunk in the sea, and then it had to be removed. So his idea for a patent application was centered around this concept, and yeah, so he filed it. But his idea was rejected, and I'll tell you why his idea was rejected. Because the examiner in the patent office who was examining the patent application, because once you file a patent application with the patent office, it will be examined by the examiner. So patent examiner found a reference in a cartoon series of Donald Duck. So in that cartoon series, what happened was Donald Duck was captain of a ship, and when a part of a ship was sunk, Donald Duck also filled that part with some Costco balls, or some ping pong balls to be accurate, and then applying the concept of buoyancy, he lifted that. So this idea was not published. It was a cartoon. It was a cartoon basically, which was streaming on some platform. Based Since the mere idea of buoyancy and lifting a sunken object was already included in a comic book, so the idea of the Danish inventor was rejected by the patent office. And when we are discussing this, I think I'll quickly just mention that when we are analyzing novelty of an invention, we are looking for a published document. So, if I conceive invention today, anything that is published before today will be considered a prior art. That will be a prior art for my invention. But while we are analyzing inventive step, any uh, idea or concept, even if it has not been published, but it is in a common knowledge or it has been somewhere disclosed, then it will be affecting or it will be attacking the inventive step of the invention. As I mentioned, that a novel, that a cartoon, a streaming cartoon was not published anywhere. It was not in the form of a paper, but it did exist. It was in a common knowledge, so it was rejected. Similarly, Steve Jobs, the founder of Apple, sometime in his speech had mentioned a technology called rubber band technology, which was related to some processes of processing of an image. And when after few years, Apple filed for a patent application for that. That patent application was rejected because this idea of using this technology for image was already disclosed by Steve Jobs in one of his speeches. So this is how inventive step works. Similarly, once there was an invention wherein there was a door, and in the lower part of the door, a sensor was kept, and whenever a pet dog used to come near that sensor, the person who was inside the house could get an idea that this is my pet dog, and they used to just lift the lower part of the door or press a button, and the lower part of the door used to get open, and the pet could enter the room. So this invention was filed with the patent office, but this patent application was again rejected on basis of being an obvious invention, because similar kind of concept was disclosed in a comics of Dennis the Men. I think many of you might have read those comics as today. So in that comics also there was a comic strip, and there was a comic strip in which the similar idea was disclosed. So the strip had shown that there was a door, there was a sensor, the dog was coming, and dog was making some noise, and the door opened, the dog entered inside the door. This comic book was published as a was cited as a prior art to the patent application. However, the applicant of the patent application successfully convinced the examiners that his invention was different, and then he was granted the application. So, I'm just giving these examples to make the complex concepts of patent law a little more interesting for you, so that you can relate to it. Now, I'd like to briefly touch upon one topic that is really relevant for all of you, and not for all of you, but all of us, and that is compulsory licensing. So, a few years back, in case you haven't heard, maybe you can, after this session, you can go back and read on it. There was a really expensive drug called Nexavar for treating lung cancer and breast cancer, and it was originally patented in favor of Novartis. All of us know that Novartis is a big pharmaceutical company, foreign company, who has many patents and who has good R&D capabilities. So Nexavar was their drug, but Nexavar was but back then in 2012, full dose of Nexavar used to cost 4 to 5 lakhs for a patient, and that was not affordable and for most of the citizens in India. So there is a regime under the patent law that's called a compulsory licensing, when applying for a compulsory license for a drug, you need to show that the patented product is not affordable, it is not accessible, it should be made available at a cheaper price. So Novartis' drug, so till date in India, only one compulsory license has been approved by the Indian Patent Office, and that is for Nexavar, that is drug of Novartis. And once the compulsory license was granted, the drug was made affordable to most of the citizens of our country. So this is one of the landmark cases in patent law. In case you are interested, you can go through the details. Now, one second instance of a really interesting case in patent law that I like to discuss is Monsanto, and I assume that will be relevant for most of you because it related to a biotech concept, and which a biotech concept which was patented by Monsanto. So we all know that India has been one of the major producers of cotton in the world. But initially, when our farmers used to sow cottons in India, it used to get infected by a pest called pink bollworm, and pink bollworm used to destroy hectares and hectares of and like acres of farms of cotton. So it was a concern back then in India that how can we just save our crop, and how can we increase our supply of cotton. Then Monsanto, we all know Monsanto is again a biotech giant in industry. So Monsanto came up with a technology, and their technology utilized a gene sequence in a microbe called Bacillus thuringiensis. They extracted a gene out of it, and when these genes were assembled in a vector and inserted into the plant, then it resulted in increased production of an endotoxin in a plant, and then once the pink bollworm used to infect the plant, with this technology, with the gene, or which was invention as per this technology, it used to produce an endotoxin inside the plant, and the pink bollworm used to get neutralized, and they were unable to attack the plants. So this way, the crop plants became resistant to the pest because of Monsanto's technology. But what happened was that, as I had already mentioned, that you cannot get a patent on a plant. So most of the seed companies in India, they filed a case before the court that Monsanto's patent technology is directed towards the plant, so they cannot. So this patent is not. So this patent should be set off. It should be scraped, and so this was it. However, Supreme Court was of opinion that since this is a technical matter, it needs to be dealt in merits in detail, and presently Monsanto's patent is subsisting, and this case is still before the court. Any one of you who's interested should read about it, should follow it, because it's a rather interesting development for science, especially for agricultural science, because it affects plant varieties as well, which I'll be dealing in detail in coming minutes. Yeah. So I have tried to cover a few basic concepts of patents. Now we'll discuss trademarks. So trademarks is really simple, something that we all can relate to. You go to market, you see a packet which it has blue and white cover. It has written Arayo, and then you see a similar packet which is also blue and white, and it is Oreo. You will definitely buy Oreo. Suppose I again similar packing and I write Chorio, you'll still buy Oreo. So this is the power of a brand, and this is the power of a reputation. Once you are buying Oreo, you get Oreo inside it. So this is a trademark. Uh, for trademark also, it's pretty simple. You just file an application for registration before a trademark registry, and you get protection for your trademark. But in India, in case, even if your trademark is not protected, suppose today I start selling few organic products under the brand name organic organic life or something like that, and I have not registered it, and any one of you comes up with a green tea or similar product with organic life, even if I'm not registered, I can stop you, because in India, reputation and goodwill matters as for all of us and individuals. Similarly, the same principles are applicable in case of trademarks. So whenever you have attain a goodwill and a reputation, then you can stop anybody else from selling your product, even if you do not have a registered protection. Some really interesting case that I like to share are that I hope that all of you have been to Delhi at some point of your life, or maybe some of you are from Delhi. So in Malvi Nagar, there used to be a coffee shop called Sardar Baksh. So when I hear Sardar Baksh, when I see Sardar Baksh with a white and a green logo, then I'm also reminded of Starbucks. So Sardar Baksh and Starbucks are confusing when you look at them and when you pronounce them. But court was of opinion that Sardar Baksh couldn't sustain because it was confusingly similar to Starbucks, so it had to get closed. Similarly, Christian Louboutin, I think all the girls love their shoes. Christian Louboutin is a really expensive shoe which has red sole, and that red sole has attained a reputation. So if I try to come up with a shoe or heels with a red sole, I think I will have to stop because Christian Louboutin has a registered trademark. Now, Christian Louboutin is registered in US or maybe in other countries. So can they stop me in India? They definitely can, because under Indian law, we have a concept of cross-border reputation. So while we are discussing cross-border reputation, I'll again share a small anecdote from my professional experience. So while I was new into the profession, the second or third trademark litigation case was related to trans-border protection. There was a famous restaurant in London under the Vida Swami branch. The restaurant name was Amaya. Amaya means a light of moon or something like that. Pretty popular name these days. So the owner of London chain had approached us, and he just mentioned that someone in Gurgaon had come up with a eatery named Amaya. But our client, who had trademarks protection in London, didn't have any trademark protection in India. However, when the case was argued before the court, we were able to show that there were multiple news articles or awards and recognitions and customer testimonials in London, and there were some publications in India as well about the restaurant. And in this way, we could have we were able to demonstrate the goodwill and reputation, and so the Amaya in Gurgaon had to shut down its operation. Yeah. Similarly, Burger Singh, confusingly similar, but in this case, I think Burger Singh still continues to operate because it has shown that it has a standalone operating and a standalone reputation of its own. So whenever you come to Delhi or in other major cities, you may come across Burger Singh. I think that is totally fine. So now I'm done with trademarks, and I hope whenever you go to any other city or a small town and you see simple Haldiram, like Haldiram Mithai Wala, I hope you will be able to distinguish that this is like a standard case of a trademark protection or a trademark infringement. Now, one of my favorite forms of IP is copyright. So, once I started my session, I said that a patent is for an idea, so copyright is for an expression, and a really simple way to explain that will be that an underlying concept that has been discussed, elaborated in many songs, many books is Radha and Krishna meets on the bank of Yamuna. Now, Radha and Krishna meet on a bank of Yamuna as a concept. I say that Radha, along with her friends, Krishna, along with his friends, with few cows, meet at the bank of Yamuna on a full moon day. I have come up with this description. So underlying concept is Radha is meeting Krishna, but I have added separate forms to separate new expressions to it. Similarly, if I just say that Radha and Krishna have met on the banks of Yamuna and they are rejoicing, colors of Holi. Similar, I have just copied it from there. They are sitting on banks of Yamuna, but colors of Holi and they are playing Holi is my own expression. So in copyright, multiple expressions, even if they have a common factor, they are eligible for copyright expression. One of you writes a book, How to Make a Biryani in Vadodara. And I also, while sitting in Delhi, write a book on how to make a biryani. Even if there is a similarity, if I am able to prove that I didn't have access to your book, and there was no way for me to get access on your research, and while I was preparing my book, then I am able to get protection for copyright. So copyright is, while patent, the tenets of patent law are novelty and obviousness. For copyright, it has to be original. So whatever you have not copied, whatever is your own expression is original. So this is it. Now, again, when we are looking for some good examples for copyright, that will be Jai Ho. We all know that Jai Ho is famous song by A.R. Rahman, and A.R. Rahman won Oscar for this song Jai Ho. Then after some time, Salman Khan and A.R. Rahman were in a legal battle for the expression Jai Ho, because Salman lifted the expression Jai Ho and he used it in his movie. I believe there's a movie with this title. So since Jai Ho was A.R. Rahman's expression, it cannot be copied as it is, right? So this was it. Similarly, Ram Sampath is one of music directors who had composed one tune for Ericsson. And after a few years, Hrithik Roshan's father had made a movie, and the similar tune was copied in that movie. Once you, I think you can all Google which tune was that. It is pretty it is pretty catching. The tune is still playing in my mind. So these are the classic case of copyright infringement. You lift something and you paste it somewhere. Similarly, what designers do is Masaba Gupta. Masaba Gupta has some prints, and she uses really unique prints of with plants and animals on her clothes. And we usually go to these local markets, and you see that there will be a cloth with similar prints of leaves, elephants, and they'll sell it as a Masaba print. Even in the Netflix series, if I like, I have watched the series Masaba, you will see that there is a reference to that this is a Masaba print. But she says, but this is my print. But she says, how come it is your print? So it is her print, and this is the classic case of copyright infringement. So, So here I like to mention one thing, that intellectual property is something which is very important to all of us, because all of the case, be it patents, be it trademarks, or be it copyright, I'm citing those examples which are like commonly seen, commonly observed by all of us. So this way you can always relate to what is a classic case of infringement. When I use the term infringement, I hope you know what is an infringement. Infringement is when you encroach on somebody else's right. Yeah. So now coming to design. So design is something that is that can be viewed. So while I'm holding my phone here, I hope you can see here. This is a design, right? Then when I'm holding a Coca-Cola bottle, you see that curved bottle shape, that is a design. So whenever you come up with a unique design, you can find an application for it. I'll again like to reiterate that whenever you approach an attorney for IPR protection, never ever say that I applied for a design patent and I got it within 2 months. Firstly, so I'll tell you what is wrong about this sentence. Firstly, there is no design patent in India. In India, it is just a design. So what you can say is, I filed a design application. Then you get it in 2 months because the examination process for design is pretty simple. It is not as onerous, as aggressive as the patent examination. I'll say aggressive because patent is technical, and usually you will get lot of technical documents once you're as an objection from the examiner whenever your application is examined by the examiner. So it is simple, like your professor. Whenever you will submit a paper, your professor will say, no, this is copied from here. No, this is copied from here. Your paper is not eligible for printing. Please go rework and then you come back. So similarly, patent office will tell you this, right? Yeah. So while we are on design, some really interesting cases are of Ferrero Rocher. Ferrero Rocher are those chocolates. They are these round chocolates with some other designs to it, so they are eligible for designs. Now, one case related to design uh, protection was related to that I dealt was related to cello bottles. So cello bottles have a unique shape, but the other party was also making the bottles with a similar shape. So they had to stop because this unique shape of the bottle was already owned by Cello. Similarly, helmets. We all know helmets are like most of the helmets have a common design. They have a front opening and then there is a black case behind it. But where in helmets also there are a lot of variations. So when there are a lot of variations, then these all the variations will be different designs and are eligible for design protection. Now, the other form of IP that I like to discuss is geographical indication. Geographical indication is self-explanatory. You go to Allahabad and you buy guavas which have pink center. Then you go to Banaras, you buy Banarasi sari. You go to Punjab, you buy indigenous golden rice variety. Then you go to Chhattisgarh, you buy that painting with the unique. There's a unique painting. I don't know what that pattern is called, but you buy that. Then you go to France and you go to Boulevard and all of these different places in France, and you buy wine from there that is made from the grapes that go exclusively grow there. So these are geographical indications. So geographical indications are unique to that place and they grow in that place only. And to be really honest, I'm not an expert on geographical indication, nor have I ever dealt any matter related to geographical indication. But this is what I know so far. Darjeeling tea. Darjeeling tea is a classic example. You get Darjeeling tea in Darjeeling, then you get Darjeeling tea in Assam, then you get Darjeeling tea in Bengal, and you get it everywhere. But where does the Darjeeling tea comes from? So though there was this long impending litigation which was fought by Darjeeling Tea Trust in Darjeeling, and I think ultimately they won. So when you are trying to establish that a geographical indication should be awarded to a particular object, then you have to show that that particular object is indigenous to that place and the features which are responsible and which are attributes for the uniqueness are because of the geographical location of that place. So all the grapes that are grown in France are of that particular taste because they grow in that area of France, that province of France, and then they develop that taste because of climatic conditions. So that they will be geographical indication. Um, Now, I think one of the forms of intellectual property rights, which is not discussed, usually not discussed in detail. And I'm not even sure if it is a form of intellectual property. However, I will like to cover it in the today's session, and that is plants variety. So plants, when I mention plants variety, it is pretty simple. Whenever you have a you have, and I believe that you people will be more technically adept in understanding it than me. So whenever there is a in so there is a parental variety, two parental varieties, you cross them, you come up with your own variety. It has some unique characteristics that are stable. Then you can apply for a plant variety registration with the plant registration authority. I'll give a simple example. So while I had started my session, I was giving you an example of a tomato which has red and orange stripes. So that example was sounded quite bizarre at the starting of the session since I didn't give a background to it. But now, when we are discussing varieties, it becomes little relevant because what happens is, suppose I have two varieties of plant. One variety has some features, and then genotype, some genotypical features. Then the other one has other genotypical features. I cross those variety, and I develop a third variety of tomatoes, which has red and orange stripes, which has less seeds, more juicy, and some, and the plant is taller, something like that. So it is a unique variety with new genetic features or remarkable features which distinguishes new variety from the respective parental variety. So this variety will be eligible for plant varieties protection under plant varieties regime. And while a particular variety is considered eligible for protection under plant variety regime, it is usually examined based on the three criteria. Firstly, it has to be distinctive. It has to have some distinct features that make it different from the parental variety. Second, uniform. So it shouldn't be like I have crossed two plants and one progeny is so half of sorry so in when I grow a full progeny 100 plants, 50 of them are showing like red and this orange tomato. The rest are faded brown, faded red or faded orange. That shouldn't happen. The gene expression that you are looking should be stable and uniform. It should be uniform. Like one progeny should show uniformity. And as I've already mentioned, stability is important. It shouldn't be like your variety is showing these characteristics only in one progeny, but it should also be able to show the same characteristics or same features in the subsequent generations also. So generations by generation, it has to do that. So this is what entails the Plant Variety Act. Again, while we are discussing plant variety, I'll again like to refer to Monsanto's matter. So when so whatever is eligible for patent, it cannot go under Plant Varieties Act. Plant varieties is a separate regime altogether. So while Monsanto was enforcing its patent right against the against the seed companies were of opinion that once you insert these genes into a plant, and the subsequent plants are variety with a distinct feature, and therefore the patent extinguishes. So this dispute was at the cusp of patent or at the conflation of patent and Plant Varieties Act, and presently it is still not a settled law, and we hope we'll get an answer really soon. But the concept is pretty simple, as I've already explained. So this is what is about the basic forms of IPR. There is one another form that is called the semiconductor layout. So all of these in electronics industry, they design semiconductors. There is a layout which has chips and all these microprocessors and all. So these layouts are also eligible for protection in the Semiconductors Act. So this is it. I have given a brief overview of all the type of IPs. I've tried my best to make it more interesting rather than an extensive session which has a lot of legal terms or legal references. So in case there are any queries or questions, I'd like to take them up.
Thank you very much, madam. Now the
Thank you.
webinar topic is open for the discussion. So anyone having the queries or any questions, so they can ask here.
Neha, am I audible? Hello? Hello?
Sir, your voice is very low.
Neha? Hello?
Yes, Professor.
This question is from my student side. I have received some questions from some
The
students.
volume is so you're not audible.
Am I audible now?
So your voice is little feeble. It is not clear.
Is that clear?
I think the volume needs to be raised.
Is it clear or not?
Yeah, I think I can hear you now, sir. Yeah.
So, okay. So this question is from my student side. I have received some queries from my students.
Yeah.
They have a different kind of question. I think we should appreciate. Which things cannot be patented and what are not patentable?
Okay. So the question is regarding what is not patentable, right?
Yeah, absolutely.
Yeah. So I am just looking for an option if I can share my screen. Okay. So under the Patents Act 1970 is the legislation regarding the patents in India. Under Section 3 of the Act, there is a list of subject matters that is not patentable. So at the very starting, I had broadly I had mentioned that any subject matter which is against like moral ethics, moral standards or ethics, that is not patentable. Similarly, in field of chemistry or in field of pharmaceuticals, we all know that there are isomers, there are stereoisomers and enantiomers. I am not very adept at chemistry and I really cannot recollect everything. But at times there is a compound where OH and H are placed in a single plane, but in an enantiomer or whatever the respective the correct form is, they are just tilted and it's a mirror image. So under Section 3, any similar compounds cannot, these kind of similar compounds which are mere images of each other, they cannot be patented. But you have to show that there is an efficacy, enhanced efficacy. So when we say enhanced efficacy in case of pharmaceuticals, we have to show that it has a better medical effect on that particular disease, and then only the new form of a same substance can be patented. So alpha form, beta forms of compounds can be patented. Similarly, yeah, when actually it's a really good question because suppose today I come up with a compound, or I come up with a composition which has neem extract and which has curcumin, that is turmeric extract. I combine it and then I go to patent office and I say it has a good effect on treating skin cancer, but the objection on this kind of invention that it is merely combination of two known elements. You are simply combining two elements, and this is not patentable. Whenever you show combination, you have to show that there's an added value over and above what you have done. There's a synergistic effect. So, like the values, the respective properties have added up, and then they have treated. Similarly, in mechanical, suppose you come up with an umbrella which has some properties of circulating wind also, and you just put a fan over it. These are not patentable because this is merely a juxtaposition, and mathematical formulas are not patentable. And similarly, architecture, maps, and games, and any mental method, business methods are not patentable. Any okay, suppose I come up with a idea of a chess move that will lead to checkmate in one go, then that is also not patentable since it is a mental, it has a mental component to it. So these kind of subject matters are not patentable. In case you want to read more on it, you can simply type section 3 of the Indian Patent Act and you will get a list of subject matters that are not patentable. Any
Neha,
method of treatment is also not patentable. Any animal, plant is similarly not patentable.
Neha,
Yes, sir.
uh, if a person is going to have some kind of a value-added product with a natural form, like a sugar, if he or she is using sugar and in that sugar they are adding something, and after addition of something they want to go for the patent, is it possible?
It is possible if the there, so as I already mentioned, that there has to be synergistic effect. What is added to the sugar? If they are simple additives which do not have value, like in most of the pharmaceutical combinations, we add few adjuvants or some fillers. In if something like that is added to sugar, that is definitely not patentable. But if there is a value component that is added to sugar, like if there is a beta form or alpha form of some other compound that is added to sugar, that leads to reduction in sweetness index to an extent that it is good for diabetes patients, then a data for that in this respect needs to be given to the patent office, and this way it can be patentable.
Very nice. Any other question, Harshit ji?
Sorry, sir.
Harshit ji, any other query from anyone?
Any other questions from the students and the faculties? Okay, thank you very much. Here also is Principal and Dean of College of Agriculture, Professor and Dr. C.K. Sharma, sir. So I would like to invite him for sharing views on the today's topic.
Thank you very much, Dr. Harshit and Ms. Neha Kanjuri for giving the talk. And I think that I missed something due to some of my busy schedule. But I'm sure that the audience got the benefit to this talk, because whenever you are in the science, you always think about the patent, you always think about the copyright, you always think about the trademarks. So I think the knowledge which has been shared by Ms. Neha is very much valuable. I know her very well, and she was my student, and I know the capability regarding the field of this. I think thank you very much for that. Thank you, Neha.
Thank you, sir. Thank you. Pleasure is mine, sir. It is really rather emotional moment, and I am pretty nervous because I'm speaking in front of someone who has taught me some basic of biotechnology. So I was rather nervous, but I hope I was able to deliver well. So at the starting of my session, I was really nervous, but I'm glad that I was able to address the students and the faculty. It is an honor.
Okay, thank you very much, Principal Sir, and thank you very much, Imran, for giving the valuable information regarding the today's topic. I would like to giving my thanks to the faculties as well as to the students. Okay. This examination time, all the students join the webinar. Okay. So thank you very much, all of you.
Thank you.